get a divorce, you need to make an application to a court for divorce to be granted, based on one of the grounds of divorce. In Scotland, there are 4 grounds of divorce, and you have to be able to establish that one of them apply. Divorce is always granted based on the marriage having broken down irretrievably, but you must establish that the breakdown is established by one of these 4 grounds, and not just that it has broken down irretrievably. The 4 grounds are that the marriage broke down due to the other person's unreasonable behaviour, or their adultery. Or alternatively, based on the time since you separated, either 1 year from the date that you separated and the other person must consent, or more than 2 years from the date when you separated, when the consent of the other person isn't required. There are 2 types of procedure to obtain a divorce: simplified procedure and ordinary procedure. If you are using the simplified procedure, then you will only strictly need a solicitor at the end to notarise the papers, that is, to confirm your signature. For ordinary procedure, you will need a solicitor from the start. My advice would always be to take advice from a family law specialist to ensure that you follow the right procedure from the outset, to make sure that you don't waste any time or money going down the wrong procedural route. Which type you need to use governs whether you need a solicitor and at what stage. In Scotland, before the divorce is granted, then you need to be able to demonstrate that there are no children under 16 whom the court have to make orders regarding, and that there are no outstanding financial issues between you and your spouse that the courts have to regulate. If either of those things apply, then you will need to use the ordinary procedure. It may be that these issues can be resolved by negotiation before court, and if so, a separation agreement can be entered into, saving time and expense on court procedure. Simplified procedure is only applicable where there are no children under 16 and there are no financial issues remaining. The short answer is that there is no standard cost, as costs will vary depending on what procedure applies and what orders you need the court to make. However, at Complete Clarity, we offer a free first consultation at which I will be happy to run through all of the available options with you to identify the best and most cost-effective strategy to guide you through the process.